Hello, this is the Weekly Review, a program of Sawa Sawa Network making sense of relevant topics and news. My name is Roger Alfred Yoron Mudi. I'm the producer and host. Today, we are joined by a famous Kenyan lawyer, an advocate of the High Court of Kenya, Shadrack Wambui. He is famous. He won the People's Accolade Law Magazine Award, which considers him as a legal millennial who has shown exceptional radiance in the field of legal practice. And we will be looking at several issues concerning the freezing of the bank account of the South Sudanese Minister of Cabinet Affairs, Dr. Elia Lomuro. And been a while, counsel. Good to see you. Welcome to the Weekly Review.
Thank you, Roger, for having me. It's always a pleasure to be here.
As you already know, the High Court of Kenya recently issued an order freezing the bank account of South Sudanese minister following a case filed by the Asset Recovery Agency. The account contained sum of amount of around 13 million Kenyan shillings, and that is about $124,000 US. The ARA, the Asset Recovery Authority, said Lomoro's account at the bank made several suspicious transactions pointing to money laundering, and Lomuro on his side termed the freezing on of his account a political witch hunt. Of course, we've over the years seen several reports on corruption. Famous among them, the Sentry, for example, highlighted that some South Sudanese political leaders, businessmen, and UN-sanctioned individuals continue to exploit the Kenyan real estate and banking sectors to funnel illicit proceeds derived from plundering the South Sudan public coffers. And the US Undersecretary for Terrorism and Financial Intelligence, once in Uganda in 2018, said that South Sudanese officials, the Ugandan and Kenyan leaders must stop allowing South Sudanese officials to buy up property with corrupt proceeds, and that Kenya and Uganda lawmakers and bankers have been told that it is their responsibility to stop corrupt South Sudanese officials from taking illicit funds derived from South Sudanese conflict and investing it in Uganda and Kenya. And so, as an advocate to you, as an advocate of Kenya, what would you tell those fighting corruption and those who believe that they have been wrongly suspected or accused as far as the legal system in Kenya is concerned and its ability to deliver justice, including to South Sudanese and others?
Thank you, Rogers. Now, let me begin by first expressing my personal views. Firstly, Kenyans and Africans, and indeed every person, has the moral duty and obligation to frown upon any crime, be it money laundering, or be it any corruption, dealing, or suspicion. So as a person first, I must begin by pointing a finger that it is wrong to have people doing business or illegal business at most. But secondly, and most importantly, turning to the question, or rather the factual issue that is before us today for discussion, especially the issue about the freezing of bank accounts or the cooperative bank account belonging to the minister, Dr. Elia Lomuro. I must first express my great dissatisfaction in the manner the Asset and Recovery Agency has proceeded to freeze the bank accounts of the learned minister. Firstly, I must note.
Your camera is off.
Oh, sorry. I think I'm now on. Now, yes. Firstly, I must note that the freezing of bank accounts in this country is not novel. This is something that has been happening. And the courts, including the highest courts on this land, have had an opportunity to give a view of what ordinarily should happen. You should understand, Roger, that Kenya is a constitutional democracy. But even the agencies, this particular agency and all other agencies, including the arms of government, operate under the authority of the Constitution of Kenya, which is promulgated on the 27th day of August 2010. So, to put to perspective what the Constitution requires, firstly, previously in pre-2010 or before the promulgation of the new Constitution, fair administrative action as a right was not constitutional. In fact, it was just but a common law practice that required administrative bodies to be fair to people when they are conducting actions that are deemed to be administrative. But fast forward, post the 2010 Constitution, what we see is with the enactment, particularly of Article 47 of the Constitution, which is the right to fair administrative action that is legal, is expeditious, and is reasonable. So as far as we are concerned, in the current constitutional dispensation, a fair administrative action must be constitutional, so that it is no longer a common law practice, but it is a constitutional dictate that must be followed by all agencies and all public bodies.
So you mean the fact that the minister complained that he was not informed neither by the agency nor the bank that he was being taken to court, and nonetheless, even the sections of the law relied upon, for example, Section 81 and 82 of the Proceeds of Crime and Anti-Money Laundering Act, and other 51, Rule 1 of the Civil Procedure Rules, you know, they allow for ex parte application. So that happened, that the act relied upon didn't require the minister to be informed at that time temporarily. So, but you are citing the Constitution, which is supreme than the act.
Yes.
So you're trying to say that maybe there is bad faith in terms of not following the Constitution, just going around the act.
Just for the benefit of the viewers, it is important to understand that Article 2 of the Kenyan Constitution proclaims the supremacy of the Constitution against all other provisions of the law or statute. So to begin with, we must begin this discussion from a constitutional point of view, so that to say, regardless of whether Minister Dr. Elia Lomuro is guilty of money laundering, regardless of that fact, Mr. Elias is entitled as a person to the right to fair administrative action. And remember, we have had this discussion before in a previous occasion where the anti-corruption agency in Kenya froze the bank accounts of the learned senior counsel, Professor Tom Ojienda. And this case has gone up to the Supreme Court. Though the Supreme Court is yet to determine that issue, but the Court of Appeal, which law still stands to this minute, was of the view that investigations in and themselves are an administrative action. And therefore, to the extent that investigations are an administrative action, they must sit comfortably within the confines that have been set by Article 47 of the Kenyan Constitution. Remember, Mr. Roger, the question that probably we should be asking ourselves at this point in time is, what is a bank account? Because from the documentation I have seen regarding the freezing accounts of the learned minister is that he has a cooperative bank account in South Sudan and another one in Kenya. And therefore, what really is a bank account? The court has gone to the extent of defining that a bank account, as far as the definition of what a property is, in view of Article 260 of the Kenyan Constitution, money is a property. And therefore, money kept in a bank account, which is personal, is a property of this person. And therefore, the money that was kept in the cooperative bank of Minister Elias was or is a property of the minister. Now, Article 40 is put into operation. Article 40 of the Kenyan Constitution gives us a right to property. And it says in very explicit terms, explicit and express terms, that when it comes to the right to property, you cannot, as a person, be denied the right to enjoy that property arbitrarily and without reason or justifiable cause for that reason. And therefore, so what we see when we contextualize the provisions of the law, particularly Article 40, Article 260 on the definition of what property is, and then we look at Article 47 of the Kenyan Constitution on the right to fair administrative action, you cannot fail to frown upon the actions, the ex parte freezing of the bank accounts of the minister. And further, just to say, Mr. Rogers, if you permit me, Article 31 of the Kenyan Constitution guarantees every person the right to privacy. And you will recall that the Kenyan, if you've had the advantage of reading through the Kenyan history on how we fought so hard through a lot of blood, sweat, and tears to have the Bill of Rights as we know of it today. The Bill of Rights, Article 31, which provides for the right to privacy, is a particular right that we have fought so hard to achieve. And therefore, the question that you should also be asking yourself is the account of the minister a private account? It is a private account. And to that extent, it is improper to interfere with his private rights unless there has been any justification. And this justification must be reasonable and justifiable in an open and democratic society.
Well,
but I am aware
now regarding bad faith, for example, malice, whatever.
Yes,
it does not exonerate, of course, somebody from a crime if
yes,
it has been committed. So let's be clear to our audience. In fact, in terms of exonerating anyone, but just you are talking about fair and due process of the law. And so, in brief, what would you tell our audience that the Assets and Recovery Agency supposed to operate? How are they supposed to operate under the law while taking into account also what the freezing now means of the account?
Now we need to contextualize what has happened and then probably even offer some recommendations so that in any event we owe a duty to also members of the agency so that they can correct their illegalities and unconstitutionality. So even as much as they have an obligation under law to fight what they term as
laundering,
corrupt dealings or crimes in their entirety, we must first notice that, number one, the Constitution has elevated the place of an accused person who has been accused of crimes. So if you are accusing Minister Dr. Elia Lomuro to have committed any acts of probably money laundering, Article 50 of the Kenyan Constitution requires that a person must face their accuser. An accused person is elevated as the most favored child of the law, so that an accused person, any person who has been accused of any offense, must first be given an opportunity to be heard. Those are the rules of natural justice. And therefore it requires that the agency, the Asset and Recovery Agency, must first have heard from the minister of where he's getting this money from, what are the sources of this money, is the explanation justifiable in an open and democratic society. So if they do not justify, or if the minister does not justify of the proceeds, then it will have warranted them or have given them the impetus or the encouragement to proceed and seek an order freezing the bank accounts. But to the extent that they have not sought an explanation from him, the proceedings have been done in a very surreptitious manner, very secretive manner, which frowns or which runs contrary to the provisions of the Kenyan Constitution. Then that act of freezing of the accounts of the minister, Dr. Elia Lomuro, must be called to question. That action must be invalidated by the court of law. And we have seen, and my brother Roger, you must remember that the Constitution, even as much as it just documents, though in very little detail, of the rights that people and probably even citizens have under the current constitutional dispensation, those rights are just documented. But it means these rights must be put to action. So much so that if the educated minister feels that there has been a violation of his right, and indeed I submit that there has been a violation of his right, regardless of whether he has committed the offenses or not. So to that extent, it is for the minister to call to question the actions of this Asset and Recovery Agency. It will be remembered, and probably this is important for the viewers, that the Kenyan law, especially under Article 27 of the Constitution, dictates that we are all equal before the law. Further, Article 2 pronounces itself and says that all agencies are bound and all state organs are bound by the Constitution, so that we cannot have an agency that pretends to act in excess of the powers that have been donated by the Constitution. You cannot be bigger than your creator.
So citing
that is probably the message I would
statute.
like to give to the people.
Citing
Yes?
statutory provisions, you mean?
Yes, yes. Look, the agency is a creature of law.
Mhm.
It is a creature of a statute of law. And then it cannot purport or act to behave as though it is greater than its creator. It must operate within the confines that have been set by the Act, the Money Laundering Act. It must also act within the realm, and particularly so, of the Constitution.
Now in legal sense,
must live.
In legal sense,
yes.
What would you say? Like, what's next after the freezing of the account? Like, what's the fate of the money? In legal sense, if the minister appeals, in case he doesn't appeal, what is going to happen in legal sense?
Yes, Mr. Roger, I have had the advantage of participating in a number of asset recovery matters. And I can tell you for fact, number one, the minister must, as of urgency, if he so desires, try and call to question the unconstitutional and illegal actions of the Asset Recovery Agency. That is number one. Number two, if he fails to do that, then he means he must submit himself to the authority of the court, that has thus far frozen his bank accounts. And he can do it in two ways. Firstly, he can make an application to set aside those orders. Or secondly, he can reply to that application by putting his reasons why he thinks, or why he justifies, or the grounds upon which justify the sources of his money. So to that extent, if he does not participate in the trial, having had the information and knowledge that his accounts have been frozen, nothing prevents the agency from proceeding ex parte to set down the matter for hearing and persuading the court that since the application to have the money forfeited to the state is not opposed to have those monies forfeited to the state. So really, it is a question of does the minister see us or have a sense of urgency for the illegal and unconstitutional actions that have since been taken by this Kenyan agency? So what I must give, and probably the encouragement I must give to the learned or the educated minister, is this: equity does not aid the indolent. Equity aids the vigilant. If he's not vigilant, if he has not woken up, if he does not wake up to address his concerns, that money is going to be forfeited. It is going to be used either to buy PPEs. It is going to be used either to procure, and to hire doctors from Cuba by the Kenyan government. That money is going to be used for other purposes, other than for his own personal use. And as I understand, he has a family in Kenya that needs to be provided for. So really, this might also be a cause of a divorce, if you so desire. His family might even abandon him altogether because he cannot now provide for his family now that his cooperative bank account has been frozen.
So we're really not sure of that.
He must
that
prove and protect
money
himself.
Compared to things that have been mentioned about South Sudan, well, that money is very small. But anyway, we're not saying he has more than that. I don't know. The issue here is fighting corruption. And earlier in your opening, you really mentioned very important things about that. Just as human beings, it's important that we don't support illicit, dealings, illicit businesses, corruption, and all this. Now, in terms of fighting corruption in the context of African countries, for example, there are serious ideological issues here, and even for us in South Sudan, they're very difficult. It's a very difficult task. The circumstances are very difficult. We have enormous challenges with our legal framework and institutions, thereby even allowing corruption to happen like it's the norm rather than an exception. So we've seen the challenges, and recently in Kenya, I saw one famous economist, Dr. David D, who is influential the world stage also, he suggested that leaders involved in past corruption be forgiven. And he talked about the inability of the institutions to guarantee that corruption is fought and all of this. Now, of course, there are several people who responded. Some criticized what he said and some supported what he said. And within the context of our situation, also South Sudan, when we started, as a country, and even while we're transitioning into becoming a country, we didn't have those institutions and laws to guarantee that corruption do not happen. They were not sufficient, they were not effective, and corruption really happened so bad. And the president in 2012 called upon some of our leaders, whom he wrote to some letters, about 75 of them. He said about $4 billion got lost, and he was asking them to return the money and they would be forgiven. And he opened a bank account. He said there was a bank account that was opened in Kenya, and those people should return the money that was stolen. And some people say that was also political witch hunt. The money didn't reach that amount of $4 billion and all this. In terms of this issue of past injustices and past corruption, looking at solutions that whereby leaders can be forgiven, and what do you say? Now,
my brother Roger, first, let me begin by saying that corruption is a bad thing. At one time when the learned professor of law, Patrice Lumumba, a renowned professor of law and my former director at the Kenya School of Law, when he had an opportunity to speak to Ugandans, he said that, and I will quote, that corruption is a bad thing, and even the corrupt acknowledge that corruption is bad. So really, we are not here to applaud or rather to encourage that corruption in our countries, be it in South Sudan, be it in Kenya, or any part of Africa or the world in its entirety. But be that as it may, let us understand one thing, that the means to that end must be justified, must be done in accordance with the law, must be done in accordance with the Constitution. It has been said before that a poisonous tree will produce poisonous fruits. It cannot be expected that we will use illegal and unconstitutional means to fight corruption and justify our actions, or rather seek accolades or recognition from our illegal actions that have resulted to something probably that we might deem good. So the calling that I have is that in as much as everybody has the goodwill, and these organizations have been empowered or endowed to fight corruption, they must do so within the confines of the law.
But the law also, law can be made. So I mean, in terms of the law within, you find sovereign states are able to come up with laws, sometimes pardoning, sometimes immunities and stuff like that. But then there's also obligations at certain levels, maybe regional and even international levels. So you can see the conflicts here. And some people argue that even in the context of Kenya, whereby the suggestion that leaders be forgiven for past corruption, and that even practically it's difficult to fight all the corruption, the corrupt issues that have been happening for years, and even where to define the past corrupt actions that need to be forgiven, from when and to up to where, and how you handle that. So within that, you find there are those who would like to cite the issue of instability, for example, whereby countries are supposed to transition from conflicts and wars and become peaceful, and then reconcile and build institutions and all this. So you see, between the two, for greater good, sometimes people compromise and it happens, but then also it's difficult to harmonize that with obligations that are outside even the country.
So, but Mr. Roger, when the famous jurist Aristotle was asked what you will prefer, is it the law of man or the written law? It is documented that he preferred the rule of law rather than the rule of man. When we agree on some certain set standards that have been documented in laws, either in statute or in the constitution. Whether or not you think you are achieving a legitimate purpose by contravening those laws, it cannot be justified. That is actually an invitation. What you propose is an invitation for anarchy, so that we have laws that you think because we are achieving a legitimate means.
I'm sure you're not referring to me individually.
No, I'm just making reference to the analogy that you have made. We cannot, regardless of the legitimate purpose that we have, we cannot sideline the laws that we have to achieve that legitimate purpose that we think we are achieving. So my point will remain that regardless of what we want to achieve, yes, indeed, we want to achieve a corrupt-free society. A lot of money is lost through corruption, but we cannot do that at the expense of relegating the promises of the Constitution and the rule of law to be mere suggestions that the law has just put across that we cannot comply with. This is this is akin. I'm sorry, but this is akin to justifying mob justice. Regardless of whether this person has been found stealing, has been found probably have killed another person, this person must be subjected to due process of the law.
I've seen some arguments recently at the BBI. Some people are arguing that the people are the sovereign, so they can still change the constitution and do away with some of the processes there. Since they are the sovereign, they can use the law to even change some of the laws that at the moment do not work.
Thank you. The famous Lord Denning has written a book called The Due Process of Law. And the due process of law will probably help us in understanding what really the concept of sovereignty is all about. Now, the people, while acknowledging that they're sovereign, they decided on the 27th day of August 2010 in Kenya that let us have this constitution for ourselves and for the future generations. And they also decided under Article 255 and 256 and 257
go on.
In the event, sorry. The people of Kenya decided on the 27th day of August 2010 that in the event that we feel uncomfortable about certain provisions of the Constitution, due probably to societal changes or societal concerns, or probably some aims or desires that we have as a society, we will abide by the provisions that we have set under Article 255, 256, and 257 of the Constitution. So by coming up with a written Constitution, we almost acknowledge that some of us have, in a way, we change our desires, we change our principles, depending on the situation that we find ourselves in. And in order for us to make it difficult for ourselves, because of the inherent selfish desires that human beings have, the inherent people changing according to the situation. And that is why we had a written Constitution. So, my brother, the discussion that has been happening in courts, especially in view of the Building Bridges or the Constitutional Amendment Bill of 2020, should remind us of the importance of the process that we underwent in promulgating or having a referendum that now gave birth to the current constitutional dispensation. So it means, and this has happened before, when we had a purge on corruption, or rather, you'll recall when we had a number of cases or people arrested due to the NYS scandals, the National Youth scandals. There was a proposal from people in some quarters that these economic crimes are so monumentous, they are so big, that these people should not even be given a right to bail. But when even the lower court, Honorable Ogoti, and I was in that case, Honorable Ogoti declined to give our clients bail, citing that anti-corruption offenses are bigger than even the corruption of murder, because they involve, a larger section of the population, while murder involves the death of one person. When we proceeded on review at the High Court, the learned Justice Hedwig Ongudi agreed with us that on the 27th day of August 2010, when we promulgated the Constitution, we agreed that all offenses are bailable and the presumption of innocence runs supreme in our Constitution, so that any person who has been accused of any offense the first assumption or presumption that we give him is that he is innocent. And we cannot proceed to freeze their accounts. We cannot proceed to, to condemn them unheard. We cannot proceed to have ex parte proceedings that will result to an action that will jeopardize their life and the lives of their loved ones. So really, it's a constitutional moment.
Yeah,
I know we sometimes just run away. We run away from what we had promised ourselves because it is not convenient.
Yes,
and people condemn corruption in this country and elsewhere because they are not benefiting.
We have about 4 minutes, and I would like you to conclude by this. To people who are fighting corruption, there are people fighting corruption. They want to fight corruption, whether in South Sudan and here. And then there are those who believe maybe they are accused wrongly. Now, in terms of the ability of the Kenyan legal system to provide due process for all these, to ensure that there's justice, corruption is fought, and also those who are accused wrongly also get due process of the law. What would you tell them in terms of the ability of the Kenyan system to adjudicate all these issues?
Thank you. Regrettably, my brother, I have not had the advantage of practicing in South Sudanese courts, and probably I might not have. Sorry, yes. There was an interruption there. As I was saying, I have not had the advantage and privilege of practicing law in the South Sudanese courts, and probably I might not have a very good word to say, and I must be forgiven.
But the fighting here, I'm referring to the fight here of South Sudanese officials.
Yes. And turning to the context that I find myself in, I must speak with authority that having had the advantage of practicing in Kenyan laws, in Kenyan courts, in almost every corner of this country, be it the northeastern part and all other corners, I can tell you without an inkling of doubt that we have the best and the finest judges that this continent has produced. Judges in this country are well learned and well schooled. They give well-reasoned decisions in support or in opposition of applications or motions that come before them. And therefore, I must give confidence to the South Sudanese, my South Sudanese brothers and sisters who are probably watching us, that the Kenyan system has grown. It has grown to an extent that people enjoy so much freedoms and rights that have been enumerated in our constitution. Our courts have been very firm. They have been very outstanding in the manner in which they have called to questions, even actions of the president. That we must notice. We must also note that our courts have not shied away from declaring as unconstitutional some actions from state agencies, the president, the executive, and even the judiciary itself. We've had a situation where the Supreme Court of this country has actually declared as unconstitutional actions of the Chief Justice himself. So really, the point that I'm trying to make is this, is that our Kenyan justice system has grown to the extent that it can be trusted. The only thing that we are called upon to do, and just as Abraham Lincoln once suggested, we are called upon to protect the democracy, the democratic space that was given to us by people who...
Yes, we have like about 1 minute. We have like about 1 minute to conclude. Yet, even with all the good things you mentioned about the Kenyan system, your president acknowledged that the government loses like 2 billion every day, 2 billion shillings every day being stolen. So you are also facing challenges fighting corruption, right?
Yes, we are facing a lot of challenges. We are facing the challenge of our president disrespecting court orders. Our president has not been very faithful in discharging his roles and responsibilities as were given to him by the Constitution. Be that as it may, he is the first person to call to question acts of corruption. Really, it is also corrupt, morally corrupt for the president not to abide by the same law that swore him to power. So the point that we are trying to make is this: you cannot steal from one pocket. You cannot steal from Paul and pay Peter and justify your theft. It is wrong. It is entirely wrong and unconstitutional to have a society where people choose the orders that they want to respect, and the orders that they want to obey. So really, for the president to be saying that we have a lot of corruption issues that have not been addressed is akin to the pot calling the kettle, the pot calling the kettle black. So all manifestations of wrongs, disrespect to court orders, even these corruption cases will be handled by courts. The same courts the court does not want to obey. These people who have been accused of corruption have a right to be heard. They have a right to a fair trial. Yes, I know the president has been on record decrying or condemning the high rise of corruption cases in this country. As a matter of fact, I know he has, on a number of occasions, caused the arrest of several people who have been seen or, they have been involved in corruption. But the question that is there is this. The president oxymoronically calls upon the courts to convict and sentence people accused of corruption. The president is guilty of not obeying court orders, and that is in the public domain. So really, what is good for the goose is good for the gander. And then again, we must ask ourselves, is the president, by his disobedience of court orders, akin to a kettle calling the pot black, or a pot calling the kettle black? So the point I'm trying to make, and it will be heard and understood by our viewers, is this: that people will not be condemned or convicted and sentenced for having involved themselves in corruption if there is no sufficient evidence, if the due process is not followed. So that if these agencies defy what the law has provided as procedures and processes, then they cannot expect, rightfully so, for courts to convict the people they have brought to court. So the procedure is as important as the substance of the law. So if someone has stolen, or is alleged to have stolen, or is alleged to have laundered money, they must be subjected to the due process of the law, as Lord Denning once observed. Thank you.
That you don't want weaponization of corruption for politics. In other words, you are agreeing with David D, even if maybe partly, in terms of not using corruption for politics.
No, I am my fidelity, my brother, is to the law. Yes, I am only saying, I am saying that we should, as a matter of practice, learn to stick to what the law has provided as procedures and substance, so that if you want to achieve a society that is free from corruption, we must also be meticulous, we must be meticulous and deliberate in how we get evidence, in how we prosecute these people. But you cannot be doing things contrary to the law and expect the court to agree with you.
And also that, I'm sure, goes beyond the president alone, because you need other institutions and even other officials to work together so that you fight corruption. But then the president alone, Kenyatta, it is difficult if he is to be doing it alone.
Indeed. This is a fight that every person, every citizen of goodwill is, must participate in. Even lawyers must participate in. The beauty about having lawyers is that lawyers are just meant to ensure that we have some respect, some fidelity towards the rule of law. We are not operating by the rule of man. We are not operating under the rule of Mr. Kenyatta. No, the president, Mr. Kenyatta, no. We are operating under the rule of law. What has the law said in terms of the production, the introduction of evidence in court? If you do not follow that as an agency, regardless of how, how bad someone has been painted as being corrupt, the court will never convict such a person. He will walk scot-free. He will enjoy those proceeds of crime if the agencies do not do what is right in law. And as we have seen, the minister, Dr. Elia Lomuro, his constitutional rights as a person have been offended. His personal rights, the rights to privacy, the rights to property, his rights to fair administrative action, his rights as an accused person to a fair trial, to be given an opportunity to be heard, they have not been observed. So really, how in the fullness of time do you expect the court to emotionally rule in favor of the agency. It is not possible. So regardless of whether he has stolen that money or the money is a proceeds of crime, it is an issue. The process must justify the end. So the means must justify the end. And that is the point we want the citizens of South Sudan and the citizens of Kenya, and indeed the viewers who are watching us across the world to take home. Thank you.
Well, with that, our dear viewer, we have come to the end of our program, The Week Review. Today, we thank the Kenyan lawyer, Shadrack Wambui, very much for being with us today to discuss the issues around the freezing of the bank account of the Minister of Cabinet Affairs of South Sudan, Dr. Elia Lomuro, and other related issues. Shadrack, thank you, man.
No, I thank you. I thank you, Roger, and the Sawa Sawa Network. God bless you. God bless South Sudan. God bless Kenya. God bless Africa. Thank you.
Right, yeah. Okay.